What if I told you that gun control activists are copying the legal tactics used by groups to oppress minorities and poor folks throughout the 20th century? Just as anti-self-defense activists have tried to justify modern gun control on the basis of laws used to disarm African Americans, slaves, and Catholics from another era, they are likewise hitting the copy-paste button by stealing the same legal tactics that bigots from another era used and had to be stopped from using to harass, intimidate, and shut down the March for Civil Rights. Today, the Second Amendment finds itself on strikingly similar legal battlefields. Guys, let's get into it. So, prior to and even during the civil rights movement culminating in the 1960s, abusive lawsuits, known as tort actions, were used to silence newspapers that reported on the abuses in the Jim Crow South and elsewhere. When newspapers, whether from the South or North, dared to report about alleged abuses on cover-ups, the civil rights opponents retaliated against such papers through the excessive use of libel lawsuits. Libel lawsuits, in other words, when you sue someone claiming that what they're publishing is unfair, not true, and as a result, it's basically defamation. It's defamatory, right? This was even true, or perhaps even more true, if the article was factually correct. The African American population actually owned press in the South and had been specifically targeted and successfully interfered with for decades. Like this, using these sorts of tactics, and could simply, frankly, not afford the cost of litigation. Lawyers, not cheap. Later, when the national media began significant coverage of civil rights events, it also soon found itself the target of a barrage of libel lawsuits designed to harass, intimidate, and to defeat in court what could not be won elsewhere. These weaponized tort actions were a deliberate attempt to deter out-of-state newspapers and reports daring to cover what was going on in certain southern states. This results in two wrongs. First, a basic attack by the use of weaponized tort laws to silence free speech. Second, as a result of the first, the ongoing assault on civil rights of the targeted minorities and poor folks under the existing Jim Crow regime was able to continue. Something had to be done, and fighting the lawsuits one by one was frankly a rigged game. All right, we're going to get to the Second Amendment. Bear with me. Enter the U.S. Supreme Court in a case called Sullivan. Sullivan, in a nutshell, low resolution, checked the power of such frivolous tort actions and thereby protected the First Amendment rights of individuals to report their stories. Of course, it needs to be pointed out, everyone is free to report their stories. As St. Augustine once wrote, quote, "The truth is a lion. You don't have to defend it. Let it loose, it will defend itself." Now let's pivot to the Second Amendment with the quick history lesson aside. While coordinated attacks via the use of weaponized libel, multi-state suits, and so forth did not begin until the Alabama cases in the 1960s, the same reprehensible strategy to attack a constitutional right would find itself getting played out again in courtrooms 30 years later in the 1990s. In the 1990s, there was a crushing wave of highly coordinated lawsuits against the firearm industry brought by a conglomeration of different levels of government: state level, county level, city, municipal levels, so cities, villages, towns, that kind of stuff. Right from the very start, they were coordinated and designed to destroy the firearm industry by their intention. After all, if people cannot buy guns because we've pushed all the manufacturers out of business, then what good is the Second Amendment? These lawsuits were filed in as many jurisdictions as possible. So it's not like they just picked one particular jurisdiction, one particular court, and filed it there. They made this as broad as possible. They were further highly designed to resist something called consolidation. This is where a defendant can seek to put together many similar claims brought by different plaintiffs into a single lawsuit in order to save that defendant considerable litigation costs. Instead, these lawsuits were designed to resist that consolidation because those litigation costs were the entire point of the lawsuit. The anti-gun crowd would use the weapon of government to file lawsuits. That's your tax dollars, folks, using taxpayer-funded lawyers to force the firearm manufacturers in the private sector and other companies to defend themselves from the government-funded attacks using money that would need to come from corporate profits as well as corporate reserves. Now, this was not a fair fight, and that was entirely the point. Guys, thanks for bearing with me, and thanks for clicking on this longer video. This dense content is something I know that isn't for everyone, but if you like to see stuff like this, be sure by letting me know. Hit that like button. If you just caught us browsing through, be sure to hit subscribe to make sure you don't miss any future content. And let me know what you think about all this. Do you see some sort of lawsuit blitz like this coming out in the future? Do you think it's ever going to come back? Let me know. Post up your thoughts in the comment section below. I always enjoy joining and observing that discussion. Guys, back to the video. The gun control groups and advocates figured that they could destroy the industry and thereby the Second Amendment, even if they never won a single lawsuit. As one individual involved in the situation remarked to New Yorker magazine in 1999, quote, "If 20 cities do bring suits, defending against them, according to some estimates, could cost the gun manufacturers as much as $1 million a day," end quote. You heard me right. $1 million per day in costs. Lawsuits of this magnitude can last years. They're designed to last years. The gun control crowd would not need to win a verdict. They simply had to outlast the shareholders with their government attorneys on your tax dollars. Now, plaintiff's attorneys, that's the lawyer on the side of the gun control side. Guy named John Cole aimed for what he described at the time as a, quote, critical mass, where the costs alone of defending these suits are going to eat up the gun companies, end quote. Mr. Cole correctly observed that, quote, the legal fees alone are enough to bankrupt the industry, end quote. I wonder why no one likes lawyers. I just don't get it. And this was, by the way, no idle threat by the gun control crowd. The strategy bore pretty quick fruit and began bankrupting targeted companies, including Sundance Industries, Lawson Engineering, and Davis Industries. I realize that many modern viewers, particularly younger ones, have probably never heard of these companies. You can thank the anti-gun crowd for that. But I will point out that at the time, at least Davis Industries was one of the 10 largest manufacturers of handguns. So these were not some sort of fringe players that were easy to topple, manufacturing things with an FFL license out of their basement or something like that. These were established guys. Now, let me try some names on that I suspect many of you today will recognize. Colt Manufacturing Company stopped producing handguns for the public at this time. Do you think that's a coincidence? I don't think so. What specifically caused this? Well, facing, quote, 28 lawsuits from cities and counties hoping to punish gun makers, the company could no longer get loans to finance manufacturing because the lawsuits could be worth $0 or $1 trillion, end quote. They ran out of money to face the lawsuits by design. Here's another name that you may know. Ever heard of a company called Smith & Wesson? They were forced to accept in the year 2000 a gun controller demand in exchange for immunity from some of the litigation. The so-called compromise was brokered by, here's a guy you may have heard of, this guy named President Bill Clinton. Yes, there were deals being cut. In a nutshell, Smith & Wesson turned over broad corporate control and practices in exchange to settle the lawsuits against them. Quote, Smith & Wesson made it clear that the company was driven to the agreement by the lawsuits. The settlement would ensure the viability of Smith & Wesson as an ongoing business entity in the face of the crippling costs of litigation, the company said in a statement, end quote. So Smith & Wesson, which was owned by a British conglomerate company, decided that it was better to cut a deal that would at least ensure their existence rather than to fight what was probably correctly perceived at the time as an endless and losing war against a coordinated government blitzkrieg of lawsuit attacks brought from across the country. By the way, what were those terms, you may be thinking? Well, in part, under the terms accepted by Smith & Wesson, the company's practices would be perpetually controlled by a 5-member oversight commission. This is not unlike a corporate board that oversees the big picture while the company officers run the day-to-day. That's if you're thinking that's what it is, you're going down the right path. But publicly traded companies are often run by such boards, you're saying. So surely this oversight commission would be from interested, invested stakeholders who are looking out for the company, their customers, and of course the Constitution and the Second Amendment. Right? Right? Yeah. If you made it this far in the video, no, of course not. Instead, the cities, counties, and states that started and joined the litigation against Smith & Wesson would get to select 3 of those 5 members. If you decline to sue and join the gun control bandwagon in court, then you were excluded from the seat at the table. That was the mafia move among the municipalities and states to try to compel those off the sidelines to join them in their lawsuit blitz. Now, of course, the ATF, ever the friend of the Second Amendment, would select 1 of those remaining 2 board members to bring up a total of ATF plus the 3 rabidly anti-gun people, making up 4 of the 5-member board. This would leave the gun manufacturers with only 1 member on their own board. I shouldn't be laughing, but it's so crazy. In short, the company was no longer controlled by the stockholders or officers, but instead by a hand-picked group of gun control advocates from broadly the government. Kind of a neat little end around the Second Amendment, wouldn't you say? This is like letting the wolves run the sheep farm. Let's continue the history lesson. No other company signed the agreement, though one big name came close, Glock. Glock per rumors and my sources, that is. As the company was wavering, the then New York Attorney General, Eliot Spitzer, remember that guy? He made an ominous warning to a Glock executive, quote, "If you don't sign, your bankruptcy lawyers will be knocking at your door," end quote. Just remember this, folks. No one's coming for your guns, right? HUD Secretary Andrew Cuomo was quoted as saying that gun manufacturers who did not fall in line would suffer a death by 1,000 cuts in the next round of legal attacks launched. In January of 2005, New York City passed a law allowing lawsuits against manufacturers and dealers that did not voluntarily implement certain gun control measures that they decided. Spitzer and Connecticut Attorney General Richard Blumenthal, see how these names just keep getting recycled in current headlines too? They declared that they would sue a bunch of other fire manufacturers who had the audacity to not fall in line with Smith & Wesson. As one legal observer at the time pointed out, this would have been the, quote, first antitrust action in history aimed at punishing smaller companies for not cooperating with the largest company in the market in an agreement restraining trade, end quote. How crazy is this? That would be like suing smaller car companies because they did not agree to certain concessions in a lawsuit just because one of the big 3 manufacturers, Chevy agreed to something, therefore everybody else has to agree to it too, even if they weren't part of that lawsuit. One of the attorney generals quoted, he admitted that he did not have a shred of evidence of illegal behavior. Quote, "The point was sheer intimidation," end quote. Now, just to wrap up this sorry story that Smith & Wesson Oversight Committee, this agreement, thankfully, never went into place. And to be very clear, I am 0% throwing stones at Smith & Wesson here. We all have to consider the position that they were in. They were looking into the abyss. This was their only way out. I'm not defending them. I'm just saying you be the judge. While this was all playing out, of course, other lawsuits marched on now that the legal attack was showing signs of strong success. Unless something happened, the modern anti-civil rights movement of gun control was winning the war thanks to the bigoted tactics from 40 to 50 years before. Then in 2005 came from Congress the Protection of Lawful Commerce in Arms Act, the PLCAA. This is a U.S. law passed in 2005 that protects fire manufacturers and dealers from being held liable when crimes have been committed with their products. Much like the Sullivan case from the U.S. Supreme Court served to check the power and corruption of weaponized lawsuits in the Jim Crow South. The Protection of Lawful Commerce in Arms Act accomplished basically the same thing against the anti-self-defense advocates of the 90s and early to mid-2000s. Has this worked? Well, as of 2020, at least 6 courts across the federal, state, and appellate levels have found the law to be constitutional. Notably, one appellate court in Pennsylvania found it to be a violation in the year 2020. Remington Arms paid a $73 million settlement with the Sandy Hook plaintiffs in 2021 regarding its alleged violations of state law, specifically Connecticut's Unfair Trade Practices Act. Although the PLCAA protections had been raised by manufacturers in Sandy Hook negotiations prior to the settlement, a similar but entirely separate case had been declined by the U.S. Supreme Court in 2019. That's that Remington Arms Company versus Soto, S-O-T-O. Now, 2 cases nationally have been taken to a jury trial. One results in an acquittal in Alaska when a gun store was sued when someone bought a gun there that was later used in a murder. The second one resulted in a $6 million loss and judgment against a gun store in my home state of Wisconsin after a firearm sold there was alleged to have been negligently sold there as part of a straw purchase was used to shoot 2 police officers. In 2010, the Supreme Court declined to hear a case in Leto, L-L-E-T-O versus Glock, ending a lawsuit against Glock by the family of victims in the Los Angeles Jewish Community Center shooting. The Brady Center and families of victims of the 2012 Aurora, Colorado shooting sued Lucky Gunner. Remember that great website? Still going out there? The online store where some of the ammunition was purchased from. Federal Judge Richard Paul Match dismissed the charges. He ordered the plaintiffs to pay Lucky Gunner's legal fees under a separate Colorado law. By the way, if you don't know Lucky Gunner, fantastic ballistic gel examinations that you can look at where they test all sorts of new ammunition that you can buy on their website. They're not a sponsor, just a fan of Chris Baker and Lucky Gunner. I could go on with a list of wins, losses, and compromises, but I want you to understand that this is a very real and ongoing attack on the Second Amendment that has worked in the past. If you want me to cover some of these cases, especially some of the larger ones, such as Gustafson versus Springfield Armory, let me know down in the comment section below. Or in 2020, you've got the National Shooting Sports Foundation versus James. It just goes on and on and on. Let me know in the comment section. Notably, it's worth pointing out that this is not some sort of special deal that only exists for Second Amendment and firearm manufacturers, as I see a lot of anti-gun people say. We already talked about the fact, for instance, that journalists and news outlets and so forth have special protections thanks to the U.S. Supreme Court. However, they are not alone. Vaccine manufacturers are exempted from civil liability related to adverse vaccine-caused events by the National Childhood Vaccine Injury Act. Internet service providers, ISPs, are exempted from defamation and copyright infringement suits by Section 230. Airline companies were exempted from liability suits connected to the September 11th, 2001 terrorist attacks, and so on. I guess here's the quick bottom line for me, because this video is frankly already way too long. If this was about the principle that manufacturers in general should bear the responsibility of what their customers or whoever the ultimate end user is with their products, then frankly, we would probably have no products in our lawyer litigation happy environment. Car manufacturers would go bankrupt due to car accidents. Alcohol manufacturers would go bankrupt for, well, frankly, a lot of things. Computer manufacturers, for every illegal act of a computer that they ever sold, we'd be litigated back to the Stone Age, the end of products. At a certain point, this is about individual responsibility. And that isn't to say that corporations ever bear zero responsibility, but it is to say that this is a grossly incorrect place to draw the line, or else it leaves us with logic that regresses our civilization some 400 years into some sort of pre-industrial state. Is that really the progress that people say that they want? Our quote of the day comes from George Adair, quote, "Everything you've ever wanted is on the other side of fear," end quote. Or hopefully not on the other side of a lawsuit. Hope you enjoyed this video. I look forward to seeing your comments in the comments section, joining the discussion down there. And as always, I will see you in the next one. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.